We have a distinguished moderator here today to lead the panel, and that is Judge Ryan Holte. Judge Holte is a judge on the U.S. Federal Court of Claims, and he received his JD from the University of California Davis School of Law. He also received his BS in engineering from the California Maritime Academy. And he was formerly on the faculties at both Akron Law School as well as Southern Illinois Law Schools before joining the bench. He also has a distinguished career in private practice doing IP work as well, both at Jones Day and at Finnegan. So we are delighted to have Judge Holte here leading our panel, and I will turn it over to Judge Holte to introduce the panelists and to start our afternoon. Thanks, everyone.
Great. Well, thank you very much, Donald. Can everybody hear me okay? Great. Well, it's wonderful to be back on stage. I've attended these events as an academic for a very long time, and now it's a great pleasure to attend them as a judge and to sit with all of you and meet another distinguished group of people. Still a law professor at heart. It's great to stand up and talk in front of people for far too long. So hopefully we'll be able to follow a little bit of precedent as we had yesterday and be able to end lunch maybe a little bit early for the beach, but no promises. So today's panel is titled Regulation of Emerging Risks, Precautionary Principle or Risk v. Risk. While I was a law professor, I'll have to admit that the topic was a little bit confusing to me. So I'll introduce our topic now with a little bit of detail, and then I'll introduce our panelists and then hand things off to them. And I'll note at the onset that I had my University of Chicago law clerk put this description together. So I asked him to use little words, and he still confused me. So I asked him to repeat it, and we'll see if I can get through it. But I'm gonna read slowly here. So the fundamental questions that we're going to ask today center on how you regulate uncertain harm and most appropriate methodology to assess the risks related to harm. And as a bit of background on the subject, precautionary principle. This is a broad philosophical and legal approach to innovations with a perceived potential for causing harm when extensive scientific knowledge on the matter is lacking. It emphasizes halting and reviewing developments to resolve uncertainty before applying new innovations. Critics argue that the policy is vague, self-canceling, unscientific, and perhaps an obstacle to progress. And now I think it is directly applicable to the bench, and I know a number of my cases have waded into this issue. So a quick example in the environmental context, some argue when an activity raises threats of harm to human health or the environment, precautionary measures should be taken even if some cause and effect relationships are not fully established scientifically. In this context, the proponent of an activity rather than the public should bear the burden of proof. So with that, I'll introduce our speakers and give a quick summary of what they'll be talking on and then hand things off to them. And they'll be speaking in this order from your left to right. So first is Elissa Philip Gentry. She's an assistant professor at Florida State University College of Law. Her research focuses on the valuation of risk, particularly the value of statistical life, the value of statistical injury, and the regulation of pharmaceuticals. Professor Gentry will be discussing the precautionary principle and risk analysis in the context of uncertainty in health and pharmaceutical regulation. Next is Charles Santerre, a professor of food toxicology in the College of Health and Human Sciences at Purdue University. He served as a senior policy advisor for agriculture and health in the Office of Science and Technology Policy, where he played a key role in the development of executive orders related to the regulation and growth of the biotech and agricultural industries. Professor Santerre will be discussing the precautionary principle and its implications on public health policy. And finally, Gary Marchant is a Regents professor and faculty director for the Center of Law, Science, and Innovation at Arizona State University's Sandra Day O'Connor College of Law. In addition to being interested in artificial intelligence, Professor Marchant's life was actually saved by artificial intelligence last August. So that might be a good question to send me on the iPad up here. Professor Marchant will be discussing his empirical study of the precautionary principle in European courts and some of the challenges in applying the problems in applying the precautionary principle to artificial intelligence. So with that, each panelist will have 10 minutes for their opening remarks, and after opening remarks, I will be fielding questions from the audience, and everyone has the note on sending them up to the iPad via your cell phones. We'll hand things off to Professor Gentry.
All right. Thank you so much for having me. Can everyone hear me? Great. It's a privilege to be here, and I really am just delighted to be participating in this session. I'm going to speak briefly about two approaches to emerging risks in the context of pharmaceutical and health regulation. So we have the precautionary principle, which we'll discuss a lot later, and then we have risk. And one thing I'll say about this is I'm mostly going to be talking about cost-benefit analysis. And it's not the same as risk, but as compared to the precautionary principle, it has a lot of the same framework. So my remarks will be extended to cost-benefit analysis as well. One of the primary criticisms of the precautionary principle is how vague it is. And this kind of shows up in the definition of what is the precautionary principle. There are at least two versions of this, a weak and a strong one. The weak version basically says that the lack of decisive evidence of harm should not be grounds for refusing to regulate. That is, that you don't need to be certain about the existence of harm before you take any action to regulate it. And this is a relatively innocuous statement. Most scholars would actually agree with this. Even Cass Sunstein agrees that this is a reasonable step forward. More controversial is the strong precautionary principle. And that would say that where there is a risk of significant health or environmental damage to others or to future generations, and where there's scientific uncertainty as to the nature of that damage or the likelihood that it occurs, decisions should be made to prevent activities that from being conducted unless and until that uncertainty can be resolved. This basically says that we have to be certain that there is no risk of significant health and environmental harm before we let an activity go forward. So you can see this is a much stronger version of this principle. Now, while this margin of safety might seem a little appealing, sort of a thumb on the scale to make sure that no catastrophic harm comes to be, what the precautionary principle ignores is that the cost of these kind of precautions could be quite high, and ignores that just because it systematically does not measure those harms. In contrast, cost-benefit analysis would require that both the benefits and costs of any sort of reform relative to the status quo be quantified and measured. So particularly in the context of pharmaceutical regulation, you can see how this could be very important. The decision to deny or grant approval for a pharmaceutical is associated with various risks. If you approve of an unsafe drug to go on the market, there are side effects that can hurt consumers. If you fail to approve that drug, however, consumers can suffer harm in the absence of that sort of treatment. So in this context, it's particularly important to take a reciprocal look at the various costs being imposed by the absence or presence of such a regulation. The last thing I want to make sure that I say before I get into my 3 points here, when we talk about uncertainty, what do we mean? So a risk is the probability that a particular outcome actualizes. Uncertainty is when that risk is unknown. Now we say unknown, but what we really mean is that there's a range of potential values this risk can take on, and there is a certain probability associated with each of those values. So if you think about it, we can actually think of this as a compound lottery. It's a lottery of lotteries, and we can actually use this kind of mechanism to evaluate uncertainty and come up with an expected value of an uncertain risk. And that is the principal way that cost-benefit analysis would handle uncertainty. It would compute the expected value of the range of possibilities according to those values and the probabilities of each. The precautionary principle, on the other hand, has a preference against uncertainty. So it's the strong version of the precautionary principle would say avoid the uncertain option. So in this context, I just want to make 3 points. The first one is that the precautionary principle doesn't have the corner on precaution. There are various contexts in which the cost-benefit analysis would preach more moderate steps in the face of certain aspects. So the precautionary principle at various times can ask for action or inaction in the presence of uncertainty. And indeed, that's one of the weaknesses that has been documented, people have criticized it for, is the theoretical indeterminacy of its recommendations. For cost-benefit analysis, in the presence of irreversible harm, so risks that harm will occur that prevents, that cannot be reversed and prevents strategies from being implemented in the future that are currently available today. There are assumptions under which regulators can rationally choose to take minimal steps in order to preserve future flexibility. So there have been models that kind of display this, but the takeaway is, in the presence of irreversible harm, cost-benefit analysis could preach precaution. Irreversible harm can look like a couple of different things. It could be the depletion of a resource or extinction of a species. It could be the development of an antibiotic-resistant strain of bacteria. It could be the tipping point in a pandemic. And these vary in their range of irreversibility, but it means that it would cost a lot more or potentially be impossible to reverse damage. And because of that, it can limit the strategies that decision makers make, are available to decision makers in the future. In the presence of this, cost-benefit analysis could preach restraint. So one example of this is the tipping point in a pandemic. So at the very beginning of the pandemic, the uncertainty about how the virus was spread was relatively high. The research on its spread was rapidly offering new insights. At that beginning point, there could have been a very good argument saying that restricting activity at that point could be justified in light of the high option value of waiting, the information gained even by days of waiting for new information, versus allowing it to continue to spread, with the idea being that unfettered spread would actually lead to spending more resources down the road and restricting strategies available to decision makers for less stringent intervention in the future. These are just a framework for how we can think about irreversible harm, and in that context, minimal progress would be restraining activity. Now, unlike the precautionary principle, however, would preach precaution regardless, whereas the cost-benefit analysis would say we have to weigh the costs of restraining this activity for this period against the perceived benefits of preserving options for the future. And so you can see here how these two different approaches would have a fundamentally different approach to how to think about this uncertainty. And I think that's pretty characteristic. So the second point I want to make is this. Uncertainty can actually be a very good thing in sequential decision making. Most of our decisions are sequential. We have multiple periods in which we make one decision, then we make another one. So in the context of health, suppose a patient faces a decision between a drug with a certain risk and a drug with an uncertain risk. But say that uncertain risk has the same expected value as that of the certain risk. So the patient could spend her periods consuming the certain risk drug, and she would always have a very stable risk at each period. Instead, if she were to take the drug with the uncertain risk, the experience of consuming that drug actually provides new estimates of the risks associated with that drug. So she's facilitating learning by engaging with the uncertain drug. And with those new estimates, she can make another decision in period 2 as to whether or not she wants to consume that uncertain drug or the certain drug. And through that process, they call it the multi-armed bandit, a lot of different ways of talking about this, but we're facilitating learning by exploiting this uncertainty and using it to more precisely estimate the risks of the drugs. And based on that new information, you can either relinquish the drug or adopt it more broadly. There's a numerical example in the reading that by Kip Viscusi and Richard Zeckhauser, but a real-world example of this is the off-label use of drugs. So the off-label use of drugs is the prescription of drugs for purposes for which it's not approved. So if I have a drug that's only approved for epilepsy, but it's prescribed for the treatment of bipolar disorder, that's an off-label use. When the efficacy of a particular drug is uncertain, as it often is with off-label uses, there are potentially gains from assigning uses and seeing its efficacy in the field. And so the precautionary principle would say you shun the uncertain option because you're not certain that there's no risk of significant harm. But what the cost-benefit analysis would say is that if you were to do that, you would miss out on some very informative learning, even for a short period of time. Okay? So the last thing I want to say is this. For all of the examples that I've discussed so far, we're talking from a social level. What is optimal from a society perspective? But we don't make decisions like that all the time. We are often living in a non-cooperative world. We have private actors who are competing with one another, and private value of waiting, expressing restraint, or actions like that deviate from the social value of doing that. So an example of this might be when you're doing R&D for a project and you're trying to estimate the safety effects that it might have. So for a drug going to market, before it goes to market, how safe does it need to be before it gets to market? Suppose that society agrees from a social planner perspective, it should wait another period. We believe that based on the information we're getting, we would have sufficient information in the next period to justify the cost of waiting. Everyone agrees about that. However, I'm a pharmaceutical company, and the longer I wait, the more likely it is that someone else will come and steal my market, right? And so the costs to me of waiting are much higher than the social costs. And we can see private value deviate from social value in that way. And the reason, and because of that, we do at times want regulation to coordinate these private actors. And the reason I touch on this is because some scholars have pointed to the existence of pre-market approval as evidence of the precautionary principle. And I think that might be, I don't think that's quite right. I don't think the existence of any sort of default regulation requiring companies to give information about the risks of their job necessarily means that we're using the precautionary principle or that the precautionary principle is the right way to go. Creating public information about the risk of a drug is one of the benefits of any sort of regulation. This policy is associated with its own costs. So the way to proceed is to say, one of the benefits we'd like to see from a policy is when actors with private information have incentives to bring that private information into the public domain. And incentivizing them to do that is a benefit, but there also might be costs associated with them. And at some point, those costs might outweigh those benefits. So, thank you.
Thank you, Professor Gentry. Now, Professor Santerre.
Yes. So I decided to take this in a direction in my discipline to answer the question how a toxicologist sees the precautionary principle from a public health perspective. So the challenge that we face as a world is to fight animal and plant diseases and pests so we can feed the global community. So let me give some context to this. In recent years, China, with 1.3 billion people, relies on pork for 60% of their protein. A few years ago, African swine fever wiped out over 50% of their pigs. That's pretty significant. African crops were devastated by fall armyworm and locusts. The defoliating fall armyworm can travel 40 kilometers a day, and we're moving into Eastern Asia. Closer to home, citrus greening is wiping out the Florida orange crop. Laurel wilt is wiping out the Florida avocado crop. A virus was wiping out the Hawaiian papaya crop. A blight destroyed the potato crop in 1840 in Ireland, leading to 1 million starving and displacing 1 million people. So there's a little context of the magnitude of some of these issues in agriculture that are affecting us. So what's the proposed action? The best approach for addressing these issues is to use agricultural biotechnology. The world has been eating biotech products, and when I say the world, billions of us have been eating biotech products for the past quarter century, and we have yet to identify a single illness or death associated with the consumption of these products. While the public demands GMO-free products and the Europeans refuse to have these foods on their tables, the dawn of the next Irish potato famine may be looming. Europeans have long fought against the introduction of GMOs, or genetically modified organisms, by using the precautionary principle as the justification. These crops must be tested for decades, they say. Their disdain arises not because these products are less safe or less nutritious, but rather as a way to protect their agricultural industries from the foreign wave that would impact their agricultural industries. Oddly, Europeans embrace the use of biotechnology in the manufacture of their pharmaceuticals, the production of their cheese, and the fermentation of their alcoholic beverages. While they gladly feed American GMO grains to their livestock, they refuse to allow them to cross their own lips. You might think that this is an isolated regional issue and not much of an international concern, except for the fact that small growers in Africa depend on sales of their grains to Europe. So these small producers can't plant GMOs, and they have to pay the price when a new disease or pest visits them. Unfortunately, while Europeans use enough pesticides to protect their fields, the African farmer who cannot apply the latest pesticide is vulnerable. Maybe the greatest irony is that there is now a biotech potato which would have prevented the Irish potato famine, but the Irish government refuses to approve it for cultivation. What does the sage say about those who don't learn from the past? The USDA has now taken the position that if a new genome-edited crop is not any different from a crop that had been created by a male-female cross, i.e. conventional breeding, that regulatory oversight would be minimal. In contrast, the European Court of Justice has ruled that genome-edited crops demand the same extensive review process as transgenic crops, i.e. those crops that have added one or more genes from another species. Unfortunately, the FDA has not adopted the light touch approach for the regulation of biotech animals used for food. The first approved biotech animal was a salmon which took over $60 million in 20 years to approve. The FDA's approach to regulating biotech animals is slow, costly, and threatens to drive this technology abroad. Some researchers are planning to move their programs to Argentina in a manner similar to what European researchers did when their countries first rejected GMOs. FDA's approach is leaning toward the precautionary principle, since they are not able to articulate the risks from which they are supposedly protecting consumers. The nature of animal breeding already selects for healthy and improved animals, and there is a low probability that a biotech animal will be harmful as a food source. The World Health Organization got into the fray when they decided that the herbicide glyphosate, which is used on many biotech crops to control weeds, is probably carcinogenic to humans. The scientific evidence currently indicates that glyphosate is a safe pesticide, maybe the most safe that we have ever had in our crop production. It has a low toxicity and does not persist in the environment. The World Health Organization review process suffered from bias and a lack of scientific merit, which has added to their growing loss of credibility. Unfortunately, their ranking of glyphosate has sparked some high-value lawsuits here in the United States and caused some developing countries to ban the use of biotech crops, which could benefit from this pesticide. In my view, the precautionary principle provides no benefits for public health. It increases the cost and time for regulatory review, often with no added benefits. It discourages smaller entities from entering the marketplace and thereby reduces competition, innovation, and elevates the cost for new novel products. Globally, it is thinly veiled protectionism. Thank you.
So I'll pick on the Europeans too. So as Elissa said, precaution is different from the precautionary principle. We always exercise precaution in our daily lives, for example. We lock our doors at night and we go away. That's precaution. There's probably no one going to rob us that particular night or day. But be on the safe side, we lock our doors. But we don't weld them shut. We use sort of reasonable precaution. And so that's sort of the key question. How much precaution should we apply in any particular situation? And our regulatory agencies have always applied precaution. Charlie just gave some examples of in the biotech field. In chemicals, we apply a bunch of sort of safety factors or sort of what's sometimes called conservative assumptions as sort of worst case. And so the question is, how much precaution are we applying? Are we applying not enough, too much? And that's been an argument for decades in U.S. environmental policy. Sometimes we are applying too much. Some of the examples Charlie just gave, for example, or formaldehyde, a very important chemical. It turns out we generate this internally when we digest food. It's a very simple hydrocarbon. And one study analyzed that if the EPA risk assessment number for formaldehyde is right, we'd all have 23 fatal cancers by the time we're 60. And since some of us make it to 60 alive, that's got to be an over-exaggeration. But the question is, how much of an over-exaggeration? How much precaution should we apply? So we've been sort of applying precaution sort of under the table in our regulatory programs. It's there always. Nothing is a certain risk, or very few things are a certain risk. So almost every regulatory decision is involving some level of precaution, but we've never been very explicit about what it is. And so that's what the precautionary principle is intended to address, to say that let's make it explicit. Let's put precaution on the table expressly, and this thing was created called the precautionary principle. It arose in Europe, and Europe was the first to actually adopt this. In 1992, it was adopted as part of the Treaty of Rome. It's now built in as a mandatory requirement for any agency decision at the European level to apply the precautionary principle. But what was very interesting is they did not define it in their statutory amendment, or constitutional amendment, really. And it's not defined anywhere in any legal document in Europe. Now, it hasn't been adopted at the federal level in the United States, but a number of cities have adopted it in the United States. San Francisco was the first, and now I think about 20 cities have adopted it. Interesting enough, none of them also adopt and define what they mean by the precautionary principle. And I've collected now over 50 different versions that other groups have used to define the precautionary principle. And as Elissa's getting at with her two versions, they're all over the map. They mean very, very different things. So it's a very ambiguous question of when does this precautionary principle apply? What risk does it apply to? When do you apply it? What do you have to do with it? What does a company who's subject to it have to do? So I was talking with a colleague of mine. We're both interested in risk issues, and we were thinking about, what does this precautionary principle really mean in practice? So we decided to look at Europe, where they've already adopted it as of 1992, and we started looking through their regulatory decisions, and we found over 250 of them, but they're completely uninformative of what this thing actually means, because all they do is say, whereas, the EU shall apply the precautionary principle, therefore we do this. No explanation of what it actually means. And some of them were bizarre. For example, they used subsidizing the coal mining industry based on this precautionary principle, which made us scratch our heads, because my colleague was a big nuclear energy fan. He thinks coal is terrible. Why are you justifying subsidizing coal based on the precautionary principle? So we figured at least you judges are better at explaining things than the regulator. So we'd look at the court decisions instead. And so we went and looked at the 60 decisions that had been announced at that time by the European courts. They have the European Court of Justice and the European Court of First Instances, are European-wide courts run by the EU. And we looked at precautionary principle, and there's a lot of cases, but about 60 of them, the precautionary principle played a key role. And we published our results in a book called Arbitrary and Capricious, the Precautionary Principle in the European Union Courts. And as you can tell by the title, it was very arbitrary and capricious. And I feel sympathy for the judges there, because many of the opinions say we are required to apply this principle, but it's not defined anywhere. And so what does this actually mean? And it could mean anything. And so they're struggling, and would often in the decisions start by saying, what the heck is this thing? Now, the European Union, in response to some of the early cases, put out a communication, they called it, by the European Commission, which is a 30-page document that explains what it's supposed to be. But it, again, didn't answer any of those critical questions of when does it apply, how does it apply. It just simply said, you apply this after you do the scientific risk assessment. This is a risk management. Charlie was talking in his previous talk. Risk assessment and then risk management. This is a risk management measure after you've done the scientific risk assessment. But the question of when you apply it is a political question, which, as you can imagine, is now going to be very controversial in Europe. So that really didn't help answer the questions, and the courts continue to struggle with what it means. And so what we looked at is what do their decisions do? And they're all over the map. So first of all, some of them are fairly straightforward and sensible, because they basically overturned decisions by European countries based on the precautionary principle that didn't make any sense. And they're mostly protectionist ones. So Norway banned Kellogg's cornflakes. And the justification they gave to the court was that Kellogg's cornflakes has 19 essential vitamins and nutrients, which could potentially be harmful for some people. Even though it's beneficial for most people, it potentially could harm some. And so they banned Kellogg's cornflakes. And then, as the reviewing court said, it happened to allow the Norwegian cornflakes brand to have the sole market then. So this is clearly protectionist, and the court concluded there wasn't a shred of evidence that there's actually a harm from this. It's actually beneficial. And maybe the Norway cornflakes should put some essential vitamins in theirs. So they struck that one down. Denmark banned ocean spray cranberry juice because it had an extra vitamin C added in, and there are some people, very rare, who are susceptible to too much vitamin C. They would presumably know it by looking at the label, because it was right there on the label. It also had the effect of banning a US product while allowing domestic products, which didn't have the added vitamin C, to continue to be operated. So that got struck down too. And then France banned Red Bull energy drinks based on the theory that pregnant women in France won't know better than to drink these, and this will poison their fetus. Now, there's a lot of coffee being drunk in France. It has the same caffeine. There's wine being drunk in France. But they didn't go after any of those. They just went after it happened to be, again, an American product. And again, that got overturned as basically completely a protectionist measure with no scientific merit. But so those were sort of sensible decisions, but there were other ones that were very hard to explain and very inconsistent. So there's decisions that overturn long-standing European legal principles like fair notice. So for example, they upheld a criminal action against a manufacturer of a certain pesticide because it was unsafe, even though the long-standing precedent in the European Union is you had to be put on a list first before it's a criminal act to sell that pesticide. You have to be notified. You have to have that fair notice before you can be subject to criminal penalties. This pesticide had not been put on the list. And the European Union court said, yes, under our long-standing principles, you could not take criminal action, but because of the precautionary principle being so extraordinary, we will allow the country to put this people in jail this time, because of the precautionary principle. There were other cases where, for example, France wanted to ban UK meat because it was beef, because it's potentially affected by mad cow, and it was proliferating in the UK, seemed to be a real legitimate risk. The court said, France is relying on the precautionary principle, but the precautionary principle adds nothing new to European Union law. So you get these stark differences. In some cases, it seems to be incredibly important, overriding all other law. And in other cases, it doesn't seem to have any relevance whatsoever. And then you get just some bizarre decisions. So this one called the Pfizer case, which is not an outlier. It's the one that's now cited repeatedly in EU regulations. So it's the definitive definition in the EU, apparently, of the precautionary principle. And it's actually a pair of two cases involving antibiotics and animal feed. And this is given, it's a very controversial issue in Europe and the United States. Does it help proliferate antibiotic resistance? But it may also help make safer animals. And so there's one particular antibiotic was first banned in the Pfizer case. It's called virginiamycin. And what the court says is it goes into this long diatribe about how you have to do a scientific risk assessment first. And then you can apply the precautionary principle. And in fact, there has been a very thorough scientific risk assessment by the EU here. And it concluded there's no evidence of any risk. It didn't say zero risk, but no evidence of any risk. And the court said that is now enough to ban it under the EU precautionary principle. So, I mean, what's the point in doing the risk assessment if the risk assessment concludes there's no evidence of any risk, and then you can still ban it? I mean, the risk assessment is pointless at that. Even more crazy, there is a companion case on another antibiotic called bacitracin zinc, which is a completely different compound. And in this case, the court said there actually isn't a risk assessment on this, but there is a risk assessment on virginiamycin that found no evidence of risk, and so we can ban that one under the precautionary principle. So these are just bizarre decisions. You actually have to read it because it's just shocking, because they go through 20 pages of how important a risk assessment is, and then they completely dismiss how important that is. So this is the key case cited by the European Commission in regulating using the precautionary principle to ban things like GMOs and other things. And to me, it makes no sense whatsoever. Now, if I have just one more minute, I'll just say that I was invited after our book came out to go speak to the European Commission about this in Brussels. And it was in this huge hall with TV cameras around the whole wall. And here's this American scholar coming and bashing the EU because of the precautionary principle. And I was very polite. And I said, you know, this is very inconsistent. You need to, it needs better definition. And one after another, these European bureaucrats got up and just absolutely attacked me. They said, you know, how dare you come here? You're an American. You had slaves. You started the war in Iraq. And I said, by the way, I'm a Canadian citizen. I'm now an American citizen, but at the time I was a Canadian citizen. I can't really, you know, argue that. That's what I'm not here for. But do you have any criticism of my report? And he said, yeah. On one of the slides, you had 2002. It's 2000, not 2002. And I'd written my slides coming on the channel that morning. Yeah, okay, that's an error. But nothing else on any of the substance I talked about. And then afterwards, I'm invited to a cocktail party off the record with these same dignitaries. And they go, we are tied in knots by this thing. We can't figure out how to use it. It's being used for all kinds of crazy things, banning everything left, right, and center. And we don't know how to control it. How should we control it? I says, well, you better define it. You need to better define it. He says, we can't. We don't agree what it means. None of us can agree on that. So that's how, you know, that was off the record, but I tell everywhere I can what they told me, because after they attacked me publicly. But it's an absolute disaster to go down that road, because it isn't possible to have a principled principle on the precautionary principle. And that's why no U.S. government agencies adopted it, even though sometimes they seem to be applying it under the table.
Great. Well, thank you very much for the excellent opening comments and picks on our European cousins. So we already do have a couple questions lined up that came in, so I'll give them to the first speakers, Professor Gentry and Professor Santerre. Just a reminder for the audience, though, on your cell phone, the question should come in at slido.com and hashtag Destin2021. So first question is for Professor Gentry from the audience. Which approach would have avoided the opioid epidemic that has cost so many lives?
Yeah, that's an interesting question. I think when it comes down to it, I think it's about, I think the weaknesses of the precautionary principle miss an important part of the conversation. I think that's the ultimate takeaway. And you can apply it to a number of different contexts. But if you're not, I mean, for the opioid context, you have people who do need opioid prescriptions. There are, you know, a population of people who have chronic pain, cancer pain, and some evidence suggests that they are being undertreated for that pain. You also have people who are being overtreated for pain and addicted to opioids. This is a tough area, but if you're not looking at the potential perverse effects of any given rule and trying at least to measure and to quantify the potential harm that it produces or would not produce if it were not passed, I think you're just going to miss a big chunk of this this context, the question. This might get into issues of valuing life, and there is some public pushback against things like that. But if you don't value non-monetary aspects like lives and injuries, they tend to be left out of the conversation entirely. So I think it's a mistake to assume that the more humane thing is to not interact with these costs, not to interact with these hard questions for the sake of looking more humane, because otherwise I think we tend to ignore them and produce even more inhumane outcomes. I hope that's responsive.
Great, thank you. Next question, I believe, came in for Professor Santerre. How was the precautionary principle applied in the context of approving the COVID vaccines, considering the immediate emergency need and related uncertain risks?
Very little was used in the precautionary principle. So the context here, I guess, is that the fastest drug to ever make it through approval was probably 4 years. As a process, with many drugs falling off the edge of the cliff before they made it into the market. And the regulatory agencies working with the manufacturers were able to get this to the market in 10 months, 11 months. Pretty amazing how fast we've been able to go at this. And so FDA had to allow an emergency use of this drug, but they did it based on the data that was pretty compelling. And now, even after a couple months, we have, about 70 million people who've taken it, and we've tracked adverse events, and they're very small for a new drug. And so it's been anything but a precautionary approach.
So I guess follow up on that, if there was a strict precautionary approach, would we have a COVID vaccine?
In about 10 years. Yeah. And that's, even in the biotech world, there are people who will die because of the forces that slow these things down. And some of the things that the public doesn't see is, and this is the argument we made in the White House, is that look at biotech. There are 4 large companies in 25 years who put these products into the marketplace. So Monsanto, which is now German-owned, Bayer, BASF, which is German-owned, Syngenta, which is Communist China-owned, and the only one in the United States left is Corteva, which is a conglomerate of DuPont and Pioneer and a couple other, Dow Agro. They've been able to keep all the small players out of this. Well, I don't say they, but we've kept all the small players out. So all the universities, there's only been 2 products make it into the marketplace in 25 years from universities. Federally funded USDA labs have only gotten 1 product, the papaya in Hawaii. Small companies, they didn't exist. And that was one of the big challenges with COVID. Some of the players who got into this with this new RNA technology were the small players who were kind of pushed down because of the cost, and the regulation kept them from entering the marketplace. So the public doesn't often see that we lose all the innovation, all the competition, all the new approaches to doing things when we build these regulations. Now they kind of benefit the big players because they just added into their operating cost. But losing that competition, I think, is the biggest concern for taking on new issues like COVID.
There was a follow-up question on that related as well. What percentage of deaths are acceptable for the FDA to approve a drug? And I think, how did they come up with the phraseology and advertising that death is a side effect?
I'm not sure that any federal government agency has stated this is an allowable death. We always try to manage to the least number of deaths or illnesses. So I don't think there is a number that's said, okay, we're going to accept it if it's fewer than this versus that. But looking at the alternative, it's an easy decision of how many people will die from COVID versus not having a medicine vaccine out there.
Thank you. All right, so Professor Marchant, we're going to come back to the how life was saved by AI for you question. But first question from me first. Have you noticed any trends in the application of the precautionary principle when analyzing United States courts?
Yeah, so there hasn't been a whole lot of cases, but there has been some. For example, in some of the cities like Berkeley and San Francisco have put on warnings about cell phones and RF using the precautionary principle. And in one case, it was struck down by the court. In the other case, it was upheld. But again, with a revision because the Berkeley one was upheld even though they used the precautionary principle to justify it. But they said children should not use the cell phone. And the reviewing court said there's no evidence that this is more dangerous for children. And in fact, the risk trade-off might be beneficial for children to be safer to have a phone if they're on their own or anything. So it struck that out of that. But so it was sort of 1.5 against the precautionary principle, half for. And then it's come up in a number of other cases, but never been critical for a decision. There's a few environmental cases where essentially it's a precautionary principle without being called that. A very famous case on ethanol as an anti-knock derivative was used under the Clean Air Act with essentially, in the 1970s, a precautionary principle basis. So I monitor the cases, and it's pretty small in the US because it's not a mandatory requirement. And sometimes a party will try to raise it as a reason for this, and it's gotten varied receptions from judges.
Any other observations? Professor Santerre, Professor Gentry, on emerging trends in U.S. courts? No. All right. A question from me for Professor Gentry. It seems that there's no clear consensus related to applying the precautionary principle on developing technologies. Does this uncertainty limit the effectiveness of the precautionary principle as a tool for regulation by increasing the cost to actors trying to predict the range of outcomes of possible future regulation when applied to developing new technology?
An interesting question. So,
it was from my law clerk.
Okay, excellent, excellent. So yes, I think the precautionary principle, given how vague the formulation can be, and as Professor Marchant has said, the application of it could, I think, increase uncertainty in terms of planning investments into new technologies and things like that. For emerging risks, I think what's so interesting about those is that in areas of high uncertainty, we need to have, our cost-benefit analysis needs to be very dynamic, right? And to some extent, the precautionary principle can be seen as a static approach to changing information, which is just to say, we're skeptical until you present sufficient evidence to change our minds. Whereas maybe a better approach to kind of leverage the ambiguity, like I was saying, in a multi-sequential decision-making kind of game, is to be much more flexible to the new information and update beliefs about these various risks at each new test and use of it. And I think if you were to give that approach, we would be able to look at more technology, consider more technology, and relinquish more technology more flexibly. So it might be that as a company, you think that you ultimately might have the same probability of ultimately succeeding, but you would get that feedback a bit quicker, and it would be much smoother than having to perhaps, wait for years to amass all of this evidence and then ultimately, because of a preference against uncertainty, not meet the threshold. That, I think.
Thank you. We had another question from the crowd. And just a reminder, slido.com, #Destin2021 to send me questions. I'm not sure who this question came into, so I'll allow Professor Santerre or Professor Marchant to respond. How do you analyze minority hesitation in taking the COVID vaccine based on prior healthcare discrimination?
Well, we do have a history of testing drugs on people in the Tuskegee trials. That's very embarrassing for us as a country. I talk to my students, so I teach mostly dietetic students at Purdue, and I talk to them a little bit about vaccines because I think it gets into this trust of technology. And what surprises them is that the controversy against measles, mumps, and rubella was started by a physician who got together with a lawyer with the intent of going after this and suing pharmaceutical companies. And that's the whole start of it. And there was a very nice journalistic review of this in Great Britain, going in and doing the investigation and showing this. And the medical doctor did a study that was published in The Lancet, which is one of our more respected journals in my world, which took 2 years to retract. It was a created study intended to get to an outcome. And so when it was fully reviewed, it was totally rejected. And this was kind of the beginning of this fear of vaccines. 60 Minutes did a program on it, which made it look like vaccines were bad and getting into the marketplace without much review. And still today, one of the challenges is getting people to get measles, mumps, and rubella vaccine for their children because of fear of autism. And autism is one of those challenging diseases which is increasing in the United States, but we really don't have a good understanding of what's causing it. So the likely thing is, it's got to be this. People are looking for answers. And so there have been deaths from that. So there is this continuing idea that new technology is bad for us, and vaccines is a representative of new technologies. But it's very unfortunate because those people who are pushing away from this technology are often the ones who can get most benefit out of vaccines.
Yeah, I mean, I think across a lot of emerging technologies, we're seeing the legacy of a history of, racial unfairness now affecting, the effectiveness of the technologies. I'm a geneticist by training. There's a huge problem that most of the genetic samples we have are from Caucasians only. And it turns out the proportion of certain variants differ among different backgrounds, ethnic backgrounds. And so some of the medicines being developed and some of the treatments and even diagnoses of disease that work very well in a Caucasian population don't work so well in these other populations. And it's because we don't have the samples from those populations. And the reason is that there's this distrust because of things like Tuskegee and other examples of racist treatment of people with that. A few years ago, the FDA approved a heart drug that was only for African American people. Because that's the only group it seemed to work at, and nobody wanted to take it. Because if they're not going to give it to the white people, I'm not going to take it. They're going to, and it was intended and well intended to help that group, but they didn't trust the system because of this history of distrust. We're seeing this in artificial intelligence as well, that we're using AI today is incredible technology. It's one the precautionary principle is being applied to in some cases, it's based on data. The new paradigm in artificial intelligence, the reason it's taken off is because what's called machine learning, where you base the AI system on data, that the machine learning itself from data rather than a human programming it. That's this huge leap that we've made in artificial intelligence. But you need data, and we're finding out over and over again that the data we collect from society is biased. And we see this in the criminal justice system where we're using algorithms for sentencing, and it's based on bias. It's a biased collection of things like arrest records. And we know that, for example, Caucasians and African Americans have the exact same rate of illegal use of marijuana, where it's still illegal, but an African American is 4 times more likely to be arrested. And what goes into these algorithms? Arrest rates. And so there's this built-in racist bias that's put into it. Facial recognition systems are trained on white people's faces, white males' faces. And so it does terrible with women. It does terrible with African Americans. There's been now 3 people arrested for crimes based on facial recognition, all African American who were nowhere near the crime scene. And the police would come to their house in front of their children and take them away in cuffs, someone who has never done anything wrong, because of an AI facial recognition system errored for him, but it wouldn't err for a Caucasian. So, we're paying the price for this long history of racism, essentially, in our society. Hopefully things are changing now, and we're trying to be more balanced, but, how do you correct for that is going to be the issue. How do you get more genetic information? How do you get more data for these algorithms that's more fair? Because these technologies are based on data, and if the data is skewed, then so will be the results.
So a couple more questions came in. I'll have this one to Professor Gentry. Has a claim against a business based on the precautionary principle ever resulted in a tortious interference with business suit?
Yeah, I have no idea off the top of my head, unfortunately. I think that for the precautionary principle, I like to think of that more in terms of a government approach to risk, because we can all have different risk preferences. So if I think about that as a consumer being concerned about a business's approach to risk, I think these can be two different things. And I think there's a conversation to be had about risk preferences, ambiguity preferences in consumers, and what governments can do to aid consumers in helping them through this process. Is it true ambiguity aversion, uncertainty aversion, or is it just difficult to predict counterfactual outcomes for my own self? And what can government regulation be doing to help that? Is there a way for us to help consumers process that information? So if this is true, I don't know if this actually resulted in a case of tortious interference with business, but I think it raises an interesting questions of how individuals' risk beliefs and ambiguity preferences kind of filter up to the government, and how the interplay between these two levels can help improve outcomes overall, and not just leave ourselves to our own devices, perhaps.
Next question from the audience, and I'll have this one out to Professor Marchant again. If an administrative agency applies the precautionary principle in regulating, should courts defer to that or be skeptical of it in an APA review?
So I think the precautionary principle is a risk management decision, and that's a policy, legal, ethical decision, not a scientific one. Courts are instructed by our U.S. Supreme Court to be very deferential in an agency's scientific findings and not second guess them, under the Baltimore Gas case and a number of other precedents. But to me, applying the precautionary principle is not a scientific exercise, it's a policy decision, and therefore it should be open to more thorough review of whether it's justified or not. So I'd say yes, there should be more review of a policy aspect than the scientific aspect.
Professor Santerre, any thoughts, or Professor Gentry?
No.
No? Agree? Okay. So next question from the audience, we'll have it to Professor Santerre. How does life get valued in the cost-benefit approach?
I guess supremely. I think the idea is to save lives in every decision. So yes, I think it's the highest decision that's made is how to preserve life.
I would love to.
Yep, go ahead.
So part of my work is using methods to calculate the value of statistical life. And so when we think about regulations that preserve life or help save lives, how do we put those benefits against the cost involved in creating those procedures? And so usually we use revealed preference methodology, so looking at real decisions that people make when we balance fatality money trade-offs every day. I get into a car that is not the safest car I could potentially buy, but for me that value of money is better used elsewhere. And so you can back out to some extent how much I value marginal differences in my fatality risk. And one thing I will say about this is that we usually use an average VSL for for various contexts, and there's an open question as to whether or not we should tailor these calculations to the particular context in which they occur. Does a death that arises from one source, do we value it in the same way as another one? Will we pay more to avoid death in one context than in another? And I think a lot of work is being done on heterogeneous context. So depending on the context, we have methods to do that. We can get more detailed, and I think great work is being done to do that. But it's important, I think this is one way that we make sure we don't miss this, but we also don't overvalue it so that we create bigger risks elsewhere, because that's another problem we could have. We could value life so highly that we actually, in one context, that we're actually not consistent across the board.
Can I just add to that? So, Elissa's talked about in a regulatory context, and the OMB gives this number, I think it's 7.5 million for life saved. But what's interesting in the common law, in the tort context, where the courts are valuing life, you look at expected life and expected earnings. And so we value different lives differently based on their earnings, which, is that ethical or not is a good question. But what's really interesting is there's now people suggesting that you genetically test the plaintiff to see their life expectancy. If they have a bad gene that's going to shorten their life expectancy based on some precedents on HIV, that you can now test them to determine their life expectancy, and maybe the company would have reduced payment then if this person has a shorter life expectancy. The other really fascinating thing in that same area is the idea of telomere length being a measure of your biological age and how long you have to live. This Nobel Prize was given for that a few years ago. There's now life insurance companies using that to prorate you for life insurance based on how long your telomeres are. And so now the question is, will litigants start, and I'm writing a book on this, so there's actually lawyers talking about this, using this in a tort case to look at the telomere length of the plaintiff to estimate their life expectancy and how much damages they should get. So you guys are going to get some interesting cases.
Could I add just a little bit?
Please, go ahead.
So I thought about this question as they were describing it, and I think in the federal agencies who regulate food safety, for instance, they have to make decisions about, do we spend resources to look at Clostridium botulinum, which is 30% death rate from exposure to this, or to a virus that you might get on a cruise ship. So the decision is more of, should we have our resources going over to this thing that kills everybody, or something that goes to this virus that makes them uncomfortably sick? So that's more, in my world, that's more where the decisions are being made. You want to preserve life at every opportunity, but at some point you have to make decisions about where you're going to have your staff and your people going to. I would say we need to do a better job in the agriculture world to prioritize some of these things that I mentioned in my opening, because we don't do a good job of that. And so what I'm critical of is some of the money might going to cultivating a better marijuana crop as opposed to an Irish potato famine event that we could prevent. And I'd like to see a little bit more of a priority in our federal government to say, this is kind of how we need to address issues based on the overall impact and not just kind of randomly take them. And so I'm a little bit critical of how we dole out resources to take on challenges. But it's usually with the idea of protecting life and preventing illness as the highest.
Last question from the audience that we have now, specifically to Professor Marchant. What is the history of the precautionary principle? Where did it come from?
It came from a German word, and I can't pronounce it, but Germany, way back in the 50s and 60s, recognized this duty to protect nature, that there's this legal duty, it's called the Versus-Shop or something, some very long, it starts with a V, long German word, and that then developed into the precautionary principle. Again, the EU is sort of the leaders in this, and the US more of the followers. The US has said we use a precautionary approach, but we don't adopt the precautionary principle under both Republican and Democratic administrations. So we've resisted going down this road. I think it's because we are a much more legalistic society, and this is a very undefinable concept. It's an unworkable concept if you apply a rule of law, which I think we do more in the United States than Europe does. But it's also in a lot of now international treaties. Something like 60 different international treaties have the precautionary principle in them. The U.S. every time fights against it, but is basically outvoted by every other country in the world who doesn't have that same legal enforceability that we do here in the United States, and so it's not such a big deal for them. If we were to adopt a treaty with a precautionary principle, we would apply it, we'd have to enforce it, and we'd use our courts to enforce it. That doesn't happen in many other parts of the world. Should I tell my story about my watch?
Well, you just might have ruined the punchline there. Well, go ahead. So, how did AI save your life?
Yeah, so
last year?
this is I'm a big proponent of artificial intelligence, and I've been in a lot of debates. And now I have the clincher argument because the medical area is an example where AI is really moving very quickly, but there's a pushback and saying we're going too fast. We need to apply a more precautionary approach, more regulatory delays, and so on. Just let me give you one other example before I get to my story. So we have a company at ASU that spun out of ASU called Holte. And what they use is they look at 130,000 different measurements in your blood, immunoprotein responses, and they have an algorithm that can use this to predict and diagnose all kinds of things. It was the first approved test to diagnose valley fever, which if you live in Phoenix is something everybody gets, but there's no diagnostic test. This company's test was the first validated for that, but it can tell all kinds of pathogens in your blood. It can tell all types of different early cancers. It has all these different benefits. And what happened is the FDA met with them. I actually set up that meeting, and we had a meeting on this. And we had the top people of the FDA IVD program come, and they basically said every time your algorithm changes, you have to get a new regulatory approval. Their algorithm is changing once a week. The regulatory approval takes 2 years. So if you do the math, this cannot work in the United States. And so this year, 1 million people are being tested with that technology, and they're all in China. China says, we'll take it. It's illegal to use it here in the US because we can't regulate it fast enough. China is now using it. China has a data localization rule that data is not allowed to be returned to the US. So this is a technology developed with US taxpayer money, federal grants, developed by scientists here in the United States, and we're not allowed to use it here. Would save a lot of lives, and instead China is using it. So that's sort of the delays we're seeing in this regulatory system. FDA, to its credit, is starting to respond to this and is looking for some innovative ways. And one of the things they did was to approve the AI heart arrhythmia test in the Apple Watch, a 5.0 and later. And so I was watching this, and I was talking about it in one of my classes about it. And then this August, one day, it was one of these days where it's 100 degrees at 7 a.m. in Phoenix. And I went up for a long walk, and I came back, and I just never really felt good. I just felt really tired all day. And suddenly at 3 in the afternoon, my alert goes off to say I'm having heart arrhythmia. I've never had any heart problems or anything in my life. Called my doctor, he says, go to the emergency room. And so I went to the emergency room with all the COVID patients coming in constantly. And I was having, they confirmed I'm having heart arrhythmia, and that I'm having what they call the vascular storm, where my blood pressure and blood rate were just going off the charts. And the doctor said with 100% certainty you would have had a fatal stroke tonight if you didn't come in. I don't think I would have gone. I'm not the type of person who goes to a doctor very often, so I would have probably just toughed it out and died that night. And so, I ended up in the hospital for 3 days before they could get things under control. And now I'm, regulated with drugs and so on. But this watch saved my life. And so I was talking with the cardiologist in the hospital. He says, yeah, we're getting about 1 a week, but we're probably saving someone's life at least 1 a week from the Apple Watch. Now, one of the problems with it is if you're under 50 years old, it's about 80% of the times it does that, it's a false alarm, a false positive. But once you're over 50, it goes up, and I'm 60 now, it's like 99% accurate. So, as you get older, as many of us are, these are the type of technologies that are coming online from AI. And, in a place like Europe, they're expressly applying the precautionary principle to slow this down and basically stop it. And I just think there's going to be a lot of life saved. Our title is on risk-risk trade-offs. There's huge risk-risk trade-offs with stopping these technologies.
Well, thank you for sharing.
And I don't get paid any money from Apple.
Yeah,
I think I should, don't you? I'll probably sell 10 watches here today because of that.
And Professor Marchant has a suitcase full of watches to be sold in the hallway right after this panel. The final question I had for Professor Santerre, and if there are any more questions, I see one more that popped up on the iPad. We still have 2 or 3 minutes left. But Professor Santerre, as scientific knowledge has developed, has there been a corresponding weakening of restrictions originally based on precautionary principles?
My view of this is that the U.S. has really never gone down the road of precautionary principles. So in the U.S., I would say we've always really focused on doing good, as saving lives as our bottom line. So I can't think of one policy in the U.S. that directly relates to moving from a precautionary. I would say, having worked in USDA, State Department, the White House, and worked with FDA and EPA, that there is a tendency for federal agencies to just kind of keep building regulations and keep adding to regulations without a real 50,000-foot view of how those regulations affect industry or affect the consumer. I would say that I think it's just this tendency when I was working for USDA is let's go build another policy, and not taking that view of how do all of these policies we've developed up till now affect us, and that's kind of how I see it.
All right, thank you. So with our last couple minutes, I have one final question for Professor Marchant, and then why don't we have closing thoughts from the panel, beginning with Professor Marchant and then Professor Santerre and Professor Gentry. So final question for Professor Marchant. What is your perspective on the situational ethical dilemmas presented by advancements in AI and machine learning?
Yeah, so this is what I'm doing a lot of my work on right now. I think it's fascinating. We could have a whole session on AI. The way this is playing out across our entire economy is revolutionary. One thing I would apply a little bit of precautionary principle to, I got involved in this by Elon Musk is worried about AI destroying us at some point, and so I got invited to be the co-PI of a grant that he gave to a bunch of us, and we got the 25 top AI experts in the country from all the big companies, Facebook, Google, IBM, the military, academia, and we spent 3 years trying to deal with this problem of artificial general intelligence, that at some point the AI will get so powerful it will decide to exterminate us. This is what Elon Musk is worried about, Stephen Hawking, Bill Gates. The good news is, on average, these experts think it's about 60 years away. But no one knows how to stop it once it gets there. The solution we came up to is if we keep it confused about our interests, it will have to keep a few of us around. That's the best we could come up with. So that was kind of scary. It's the first thing that ever scared me about technology. That's coming. It's 60 years away, though, but if we saw some aliens 60 years away coming to destroy us, we'd start working on that now. So that's something we should be precautionary about. We should start working on that. But that's not what these current AIs do. They're a completely different system. And so some people are using that fear to stop these current applications. That's not the case. It's completely different. And Europe has expressly adopted the precautionary principle now to stop AI. They have no biotechnology. They have no information communication technologies because of their past, and they're about to repeat that same mistake. China, for its part, has said by 2030, expressly says this in their national policy now, they'll be #1 in AI in the world, and as a result, they'll be the world military and economic leader. And they are right. If who is going to control AI and be the best will be the world military and economic leader. And they're now outspending us. Just last week, they passed us in a number of AI publications. They've already passed us in AI patents. We still have better quality, I think. But we are in a race, and I don't think the U.S. wants to be second in this. So I would say we need a proactionary principle, not precautionary. So just to conclude, my concluding statement would be, the precautionary principle bites particularly hard on new technologies. And to me, new technologies are where so many possible benefits are out there, and to favor the old and stop the new would be a huge mistake.
Very nice. I would say I'd conclude by starting with, I'm going out and buying an Apple Watch immediately after the, that was a compelling argument for one. I think our future, well, look at our past, the last 100 years. this country is risk takers. We fly airplanes, we try new drugs, everything about our lives has risk. And if we get so fearful, we won't help the quality of life improve as we move forward. And I worry in the classroom with the college-age students that they don't have that context of seeing how we are risk takers as a country, and it's really benefited us. We've had setbacks, but we've gone down these roads that have made the quality of life in my lifetime so much better. And so in my work, in food, agriculture, and a little bit of health, I really see the precautionary principle as being a step backwards, of being too overcautious, of not being willing to take risks to improve life, to solve problems. And the examples around biotech, I think, are really good examples of how not to do things. And the Europeans are not only moving in biotech that way, they're moving in the world of nutrition also. And a lot of the decisions that I see being made and a lot of publications coming out of Europe are very much against the things that we enjoy in our lifestyle here, like consumption of meat, for instance. And so I am not a big advocate of the precautionary principle. I think there's a balance for regulatory agencies to know how to protect life and know how much regulation is needed so you don't stifle innovation and smaller upstart companies that are just getting going, the innovators. So.
Thank you. Closing thoughts, Professor Gentry?
I think I would say that in the context of health risks, the precautionary principle can seem very inviting. There's nothing that seems as important as our very lives. But I caution that this does miss the very harmful effects of the reciprocal costs of such precautions. And I urge us not to forget that. And I think the other thing I would say is, with a risk framework, we can incorporate a lot of the concerns articulated by the precautionary principle. Concerns about irreversibility, concerns about just scientific uncertainty. They actually can be resolved within a risk framework, and I encourage us to put in the work to do so. But the risk framework protects us against the perverse effects of our own over precaution.
Great. Well, thank you very much. We are right on time to end. Surf's up, and let's give our panel a round of applause.